fortunately persuasive and powerful. That the very, very few matters that get through to the courts and tribunals then exert enormous influence over what follows by establishing precedent. And the really odd thing is that the precedent is established on cases that are decided according to atypical facts. The matters that do survive the mandatory conciliation processes and the negotiation and the inordinate passage of time between the occurrence of the conduct and the judicial resolution of it are often of their nature atypical. They would have been resolved much sooner. So we get in the tribunal, and they get in the courts, to find a way of saying this in a public forum. The nutters. We get extremes. We get people who just can't be stopped at one end of the spectrum. Regardless of merit, they're there to have their day in court. And as a lawyer, yes, I used to represent people who pursue things on principle. Now, as a judicial member, I'm deciding matters brought by people who are pursuing it on principle. So you get that at one end. Now, that's not a sound basis on which to establish precedent. I don't establish precedent in the tribunal, although internally we tend to try and maintain consistency of decisions, so in a way I suppose I do. But those matters end up in the High Court, we know notoriously, certainly in the federal court from the federal jurisdiction. And at the other end, you get matters of really important, genuine principle, very, very significant issues being tried and tested. They might be the right matters on which to establish precedent. On the other hand, no disrespect, Catherine, but the judiciary haven't proved very able at dealing with matters of important principle and discrimination law, for reasons I'm about to point out. So, yes, it's a very small place to look on questions of access to justice because the justice is done much earlier in the mandatory conciliation processes. But for a lot of people, it is emblematic of discrimination, or that is the cases that come out and the decisions that are made. I have, with that experience, many complaints about the detail of the legislation, and I won't bore you with that. It could be for a long time, and I can take you through the Act and tell you why most of it's wrong or mistaken. What I thought I'd do is offer you some observations, conceptual observations about barriers of access to justice. And I think what Dr. Petrova has offered us, what Belinda, Catherine have all offered us is conceptual reasons to stop and start again. The consolidation exercise at worst is compounding, well, it's not at worst, the consolidation exercise is compounding the problem. It's maintaining a largely dated and irrelevant means of addressing a fundamental social evil, inequality. And I'm very concerned that all we are doing is compounding long-standing inadequate legislation by consolidating it. We need to reconceptualise it. I honestly don't think that that's going to happen now. It's been made fairly clear from a policy perspective that there's no political will to reconceptualise discrimination, but we can still talk about it. So, here's some conceptual observations about access to justice obstacles in the tribunal. First of all is the discriminatory nature in which we conduct our proceedings. We accord formal equality to the litigants. They're allowed to sit at the same bar table as the respondents. They have the benefit of the same rules of evidence as the respondents. I'm talking about the complainants here, the people who say they've been wronged. But we make no concession to the fact that, as a general rule, we are dealing with people who, by definition, are there because they are disadvantaged and marginalised, who are there because of their position in society. So the formal equality you extend them is the assumption that they will be able to deal with the proceedings in exactly the same way that the people more powerful than them can deal with. And we make no allowance for the fact that they're there because they lack the power. And I'm increasingly frustrated by the constraints on me as a judicial officer in having to extend formal equality to all parties. But I want to be unequal. I want to engage in positive action. I want to help people make the case they want to make. So I have this discussion among my judicial member colleagues. I get bolshy with the power given to me in the tribunal. I read literally the tribunal's powers as different from the court's powers. Now, I don't get a wig, I don't get a pension, so I'm not going to behave like a judge. I'm a tribunal member, I have tribunal powers, and I try and use them, much to the consternation of learned counsel at the bar table. But this is when I take comfort in the fact that I'm on the bench and I'm in charge. They can appeal, but I'm a sufficiently good lawyer and sufficiently exercise of powers to the provisions in the Act that give me certain powers, to be not bound by the rules of evidence, to inform myself as I think fit, and to conduct proceedings in fairness. My attempts to push those boundaries are not shared by many or most of my colleagues, and I think that's wrong. I think in this jurisdiction we are obliged, the nature of the jurisdiction obliges us to extend more than formal equality to parties before us and to engage in positive action in order to recognise the power imbalance that's before us. I'm not only speaking there of self-represented litigants. I mean, it's the fact that somebody is in a position of having been, or claiming to have been discriminated against, that brings them there, that introduces for me the power imbalance. If they're represented, that can be of assistance, although as often as I'm not assisted by counsel, who unfortunately approach this jurisdiction as some sort of add-on to the industrial jurisdiction they spend most of their time in. And they figure that if they do workers' comp, then they can do discrimination law. It's quite insulting, the ignorance with which so many of them approach the jurisdiction, call that an access to justice obstacle. They haven't read the Act before they turn up. So I would like to see us really tackle, it's a procedural question, the inequality that surrounds the way we conduct our inquiries. I'm the only one of my colleagues who calls it an inquiry, by the way. I think it is an inquiry, that's the power I have. Everyone else treats it as a hearing. So that's a procedural, conceptual approach. Let me turn to the Act. The New South Wales Act is one of the old-style acts, but it suffers the same flaws as, or the new-style acts suffer much the same flaws on the states. We treat discrimination law as the setting of a test, a requirement you have to meet in order to prove your case. Now, the first response to that, and I say that in a pejorative sense, so implicitly I think that's a problem. The Act does not set about trying to establish what happened. Our laws set about trying to make you prove that you can meet a test. Now, incidentally, that test may in part be directed towards what happened, but as much time is spent in the tribunal working out whether or not your evidence meets the tests and the requirements and what the precedents require, than simply trying to work out what happened. It's certainly easier if you're conducting an inquiry rather than a hearing to work out what happened, but that takes me back to the procedural matter. Our acts are designed to require parties to meet a test. So my first remedy for that would be, as Dr. Petrova said, to shift the onus. It's entirely unremarkable industrial legislation in Australia. We've been doing it for over 100 years. So prospective respondents really have no basis for complaining that they will be presumptively guilty, which is what I've heard them say, by shifting the onus. What it does is save them a huge amount of time, because we go straight to who knows the answer. And instead of sitting there waiting for a complainant to try and second guess what was in the mind of the person who treated them as they did, and then resisting a strikeout application because at least the jurisprudence says that we mustn't be too hasty doing that, we have to hear what the other side has to say, and 3 days into a hearing getting to hear what the respondent says, we can go straight to the respondent and say, okay, prima facie, there's a complaint here, you tell us what happened. And if what happened is not discriminatory, exculpatory evidence, you're off the hook. We haven't wasted 3 days getting there. Shifting the onus is, as I say, unremarkable in industrial law in Australia, unremarkable in Europe with the European directives. It's simply a smart way to go that recognises that knowledge of the basis for conduct is in the mind of the person accused of the conduct, not necessarily manifest in their conduct such that a third party can identify it or a complainant can identify it. So I'd shift the onus. Now that's a fairly technical way of dealing with what is fundamentally a design problem in the Act. And that is that it's designed to require people to meet a test, not to establish what happened. That takes us into reconceptualising discrimination. That takes us back to Dr. Schroeder's approach to Belinda's approach of stepping back and saying, why do we have discrimination laws? What are we trying to achieve here? What's the best way of achieving that end? And that takes us into much larger questions of systemic change rather than individual remedy. So I don't have time to detail